So, if you did not hear the news earlier today, the Supreme Court of Canada has agreed to hear the legal challenge to Quebec's secularism law. That's Bill 21. Good news, yeah, because, of course, there are several challenges to this bill. The question was, would the Supreme Court actually say they would hear it? And the answer is yes, they will. Now, of course, there's a timeline, and the big benefit, I think it's fair to say one of the big beneficiaries of this, and someone who's been pushing for this for a while, the English Montreal School Board, of course, because it directly affects them. Joe Ortona, who's the chair of the MSB, was on with Elias earlier today, and he asked him, first of all, reaction to it, and what it sort of means going forward. Take a listen.
The Supreme Court decided to hear this case. Essentially, what it means is, look, there's an important issue here, one of national importance that could have implications, throughout the entire country because other provinces may want to adopt similar legislation. The French minorities in other provinces may be affected in terms of, their right to manage and control their school system. It's a national question of national importance and a legitimate constitutional question that needs to be settled. And so what the court is saying is that they're going to hear all the, oral arguments and read all of the written submissions and ultimately settle the case because their decision is going to be final and everybody's going to have to adapt to that reality whenever that decision comes.
So a couple of things in there. Number one, I know this is in our backyard because it's the Quebec government, right? But as Joe Ortona said there, this has national implications. In other provinces where perhaps the shoe's on the other foot in their French boards and what they have to do or can't do. So there are several implications here and also several challenges. This is not just one challenge. I think the number might have been at least 8 here. So that is, as I said, depending on what side of this you're on, that's the good news. At least they will hear it. And then, of course, it'll be a matter of the judgment. I think we all recognize here in Quebec, if the Supreme Court of Canada goes ahead and says, yes, you can legally challenge this bill, and therefore use of the notwithstanding clause was illegal in this particular case, that's a whole other question. Again, I'm not a constitutional lawyer here, but remember, part of the issue with the notwithstanding clause and Quebec's use of it is it's in the Canadian Constitution, right? The use of the notwithstanding clause. The question is, was this the right way for it to be used? So there's a lot up for grabs here in terms of what the ultimate decision is going to be. I had a chance to speak to Eliadis. So she's a human rights lawyer. She's an associate professor at McGill. I wanted to talk to her about this to get a timeline on this because it's one thing to say, great, the Supreme Court has said they're going to hear it. Now what? So, Pearl, your reaction first to this.
I think this is a really great opportunity for the court and Canadian society as a whole to open up a conversation about the way in which we understand our charter, the way notwithstanding clause is used, the way in which English language, or in fact language school boards in general, get to function. This has opened up the possibility for a review of those principles.
So we have people weighing in on this saying, and obviously it depends which side you're on in this debate, obviously people in Quebec who thought this was the right way to go when they instituted the notwithstanding clause, look at this decision today and say, perhaps this is a little strange because the right to use the notwithstanding clause is within the Canadian Constitution, and that's what's going to the Supreme Court of Canada. Is that a fair argument?
I don't think it is, Aaron, because when the Supreme Court of Canada grants leave to appeal, they don't tell you why they've granted it. So it may be that the court is going to open up the Pandora's box of Section 33, but there were other arguments that were made before the Court of Appeal with regard to Section 3 around elections. There were arguments around education rights that are not subject to the notwithstanding clause. We don't know why the court has granted leave. There are 8 separate cases with, more than a dozen parties. So to untangle it all and find out exactly what's happening, we're going to have to wait for the court's decision, or at least the hearing, to see where the court is open to argument.
Can you just give our listeners an idea of what the time frame on this would be? Do we have any idea?
I'm going to give you a really unhelpful technical answer. which is that the 30 days from the application for leave, you have to send out a notice of appeal. There's another 8 weeks for the many applicants in this file to send out their record, all the documents they want to put before the court. Then another 8 weeks so the other side can do that. Same applies to all the cross appeals. And then there's going to be all the interventions. We're talking months.
Oh, my. Okay. And in the interim, despite the decision today, nothing changes, right?
Right. So until the court renders its decision, it hasn't rendered its decision.
Got it. Pearl, thank you so much. Appreciate it. So that's per Eliadis. Again, it's not happening today or tomorrow. Everyone, as she said, will have a chance to weigh in on this. It's going to be months at best before there's a final decision. So there is that to consider. Now, I will point out, and this goes, as I said, without saying, here in Quebec, people on the other side, I know Elias had someone on this morning, basically saying, okay, not the ruling they expected, but hey, it's not a final ruling. It's just a decision for the Supreme Court to hear the case. But I thought this was interesting. Yves-François Blanchet, who oftentimes can wax poetic without even realizing it, was asked to weigh in on this decision today by the Supreme Court. And I love the answer, but I love the history lesson included in his answer, so I want you to hear it. So this is Bloc Québécois leader Yves-François Blanchet on the Supreme Court's decision to hear the Bill 21 challenge.
It is an extraordinary opportunity to tell our Canadian friends that we are friends, but we are so very different. Recently, in Quebec history, a new nation decided to define itself as a nation, and it is the Quebec nation, which has been recognized as being so without condition by the federal parliament on the 16th of June 2021. It comes with the fact that for a long time in Quebec, Catholic religion held too much power. And we decided to have the priests out of the schools and out of the bedrooms of Quebecers. This is what secularity of the state is for us. We do not mind this debate being held in the Supreme Court of Canada. That's normal. That's why it's there. We do mind that every Canadian Federalist Party supports the idea to use the money of Quebecers against Quebec, against a law duly adopted in Quebec.
See, the great irony in that answer is, because he makes it sound like, you know what, this is the process, this is how it works, we're fine with that. Yet at the end, that part about every federal party spending money to get it to this stage. But then, what if it hadn't gotten to the stage and the federal money is some of the money that helped it get? See, I can't square that circle. Although I understand, in a sense, there are plenty of individual parties, private parties here who are doing the same. He doesn't like the fact that federal, parties got involved in this at all. Which is interesting when you consider now that when it comes to Bill 96, now this is about Bill 21, but about Bill 96, there was a challenge in court here, right? Here, last week, asking the federal attorney general, who's already come out Arafurani and said, you know what, we don't want to get our hands dirty. The Liberal Party, federally doesn't want to get its hands dirty and see Bill 96 get challenged. That's Bill 96. This is Bill 21. So I don't know. Pick your partner. Who you taking? I don't know. We shall see how this plays out. In the meantime, I will tell you again, as you would have expected, folks on the other side, and there has been a statement, by the way, from the provincial government. They're not very happy about this and go on about how it should be their jurisdiction and yada, yada, yada. But it is going to be heard by the Supreme Court of Canada, step number one.